Who just joined from an iPhone?
Yes.
Who just joined from an iPhone?
Judith Shines.
Thank you. Okay, Mr. Brunette, you're here on the matter with Mr. Mort.
That is correct, Your Honor. Good afternoon.
Good afternoon, and you're all set, is that correct?
Yes, as far as with Mr. Moore, I'm all set. I completed the debtor's exam. I don't necessarily have anything to put on the record, so I was just seeing if Mr. Moore could be excused since he didn't really need to stay for anything else.
That's correct. Thank you, Mr. Mort. You're all set.
Okay, thank you, both of you. Thank you.
No problem. Okay, I see Ms. Millicent Sheck.
Yes, Judge.
Okay, you were here on the matter with Michael Lewis.
That's correct.
Okay. Has he gotten on Zoom?
Your Honor, if I may, Mr. Lewis had reached out to my office this morning prior to today's hearing. We actually have settled the case. He would like to mail me a check. I've already have it approved through my client. We have a settlement amount. It's my understanding he actually has a cashier's check that he already has addressed to my client. He's ready to put in the mailbox. I would request if the court would entertain a 2-week adjournment. And as soon as I receive the funds, I'll submit a satisfaction of judgment to the court.
We'll set it for 2 weeks out.
Thank you, Judge. And Mr. Lewis, if you have any additional questions, please call my office.
April 11th at 2.
Oh, Your Honor, I did have one question. Mr. Lewis advises me that when he was pulled over, there was a $500 bond that he did pay to the court. Is the court showing that they've received that? Should I prepare an order to release that?
We received it.
Okay, I will submit an order to have that released to plaintiff if that's okay, Judge.
Okay, sounds good.
Thank you. Appreciate the court's time.
Thank you. You're all set on this matter, sir. Okay. No. Wrong file. Let's put this robust note on. We're on the record in the matter of Lansing Automakers versus Odelia Page. File number is 13-04489. Counsel appearance.
Yes, good afternoon, Your Honor. My name is Joe Brunette. I'm filling in for Tim Smith on behalf of LAFQ.
Thank you. And we have Odelia Page here. Today was the date and time that was set for a hearing on an objection garnishment. The objection states she has an installment payment order that was issued on May 13th. Our records also indicate that. We don't see though where the plaintiff ever filed an order.
Your Honor, I believe it wasn't necessarily an order submitted to the court or anything. It was kind of an agreement and a payment plan that we had arranged. We did send the defendant a confirmation letter, and she made 3 payments, but we haven't received any payments since September. So we filed a wage garnishment.
Okay, Ms. Page, did you want to address that?
Yes, I had called the lawyer's office a couple of times because they wanted me to mail a check up to Traverse City. And I said, well, is there a better way to do this? Can I do it over the phone? Can I drive down to LAFQ and just pay it there down the street? And they said, well, you can set up something through your bank where it's automatically taken out of your bank. And I said, okay, I bank with this place. You know, they're like, yeah, you can use that bank. I said, okay. So I went into my bank to try to set this up, and they were having difficulty setting it up. They said I had to go online. So I went online to set it up, and it looked like it was all set up to go through. I have multiple things being taken out automatically through my account. So I never really like paid attention just to make sure. And so it didn't hit me until I got this order for garnishment. And I was like, well, wait a minute. I thought I set this up for my credit union. So I would like to revert back to doing that and trying to find a better way instead of mailing a check to Traverse City to make these payments every month and or try to settle the debt.
Okay, I could put you in a private meeting room with the plaintiff's attorney and see if that's an option about settlement. I can't speak to that. But was she making payments on time up until that September time when she tried to set up an automatic payment?
She had missed her August payment, but when she did set up the auto payment, we received one of those auto payments in September before we stopped receiving payments. So I would say substantially yes, up until September.
Okay, I will, based on what you're providing to the court, Ms. Page, you don't have a valid objection. There was it looks like an agreement for an installment agreement or a payment agreement. And our records reflect that as well. Looks like though that you may have missed some payments. According to the plaintiff, you missed that August payment. And they may have received one of the payments that you set up through your credit union, but then, so that would show that there was something set up, but then they stopped those payments.
And I didn't get any, my credit union didn't tell me that they were stopping those. I didn't get any notification about that.
Right, but it's your responsibility to know what's coming out of your credit union and where your payments are going. If you're gonna set up an automatic payment, it's your responsibility to make sure that it's going through. They don't need to follow up on that. That was you. And I'm sure you check your bank statements periodically. You should have known that you had a considerable amount more money than you should have.
Your Honor, if I may, I think maybe we could benefit from a breakout room. I think I would like to kind of propose to the defendant a wage assignment with an actual concrete amount instead of a wage garnishment. If that's acceptable to the court.
It's perfectly acceptable to the court. So I will go ahead and put her in room 1 because you're already there. And if you all can come to a resolution on that, that would be wonderful.
Okay, thank you, Your Honor.
Thank you. Okay. You're not going to get a notification. You just need to go back to the breakout room.
Okay, thank you.
No problem.
Okay. Something's bothering your eye. What is it, Mama? I know.
Okay, we're on the record in the matter of Orbit Leeson versus Judith Shines. This is file number 21-00912 GCE. Council, may I have your appearance?
Good afternoon, Your Honor. Jeremy Chisholm, P74670. I'm the attorney of record for the plaintiff.
Okay, and Ms. Shines is present via Zoom. Today was the date and the time set for a hearing on an objection to garnishment that was filed by Ms. Shines back on March 8th. She was objecting to the writ of garnishment issued on August 5th, 2022 and October 18th, 2022, because she said a bankruptcy proceeding, but lists a case number from 2023. So that would indicate to the court, without any further information, that there was a bankruptcy filed after the garnishment was issued. Is that correct, Ms. Shines? You're muted.
Yes, ma'am.
Judge, just I checked Pacer about 5 minutes before the hearing began, and there's no record of a bankruptcy filing on Pacer right now, assuming that that we have the correct Social Security number, which I believe we do. So I don't know if possibly Ms. Shines is talking about a pending, a bankruptcy that's being discussed with counsel or something right now, but as of right now, it doesn't look like any such petition has been filed.
We have an notification here in our file in the Western District Court 23-00460. That's not accurate.
23
dash
Dash.
00460.
Maybe we do have a transposed Social Security number or something, Your Honor. Okay, well, I guess if a bankruptcy has been filed, clearly we will be releasing the garnishment, and with respect to the tax garnishment, obviously there no with respect to a wage garnishment, no future withholding should be taking place. Obviously, with respect to the tax garnishment, I don't know if Ms. Shines has filed her 2022 tax return yet, but that gets really complicated. And I guess you say we can release if the funds haven't been withheld now, we would be releasing at this point.
Yeah.
Ms. Shine, looks like you're a little delayed.
Yes. They took taxes out of mine last year and this year. They put it was on hold. My tax lady, she texted me and told me that they took it and now it's on hold because I have to go through all the court stuff to get my money back.
Okay.
The money that is being withheld, we will file a release for that, Your Honor.
Okay, I'm going to issue an order for release as well, and then hopefully that'll help. Move that release along. I also signed the court's order for administratively closing our file due to the bankruptcy stay that she pending the bankruptcy filing she has in the Western District Court. Do you have any questions today, ma'am?
No, I don't.
Sounds good. I think that resolves this for this period of time. Any additional matters for the record, counsel?
No, Your Honor. I appreciate the court's time today.
No problem. You're all set. Thank you, Ms. Shines.
Thank you.
Mr. Chisholm.
Thank you. Guys have a good day.
Same to you.
What is this doing this to mommy?
Mr. Govia? You're muted.
I'm here, Your Honor.
All right, I received a notice of hearing a motion. By way of motion, the only thing we have here is you stating that you want to claim an additional $800 total for a cell phone bill. Did you serve an amendment to your complaint on the defendant?
I do not believe I did, no.
Okay, well, you can't file an amended complaint and not serve them with that, okay? Yeah, you have to let them know. However, I do see that you already mentioned that you wanted an additional $800 here at the time of your pretrial, because it's on the joint pretrial statement, sir, correct?
Yes, Your Honor.
Okay, I don't see a amended complaint, a formal one, but I do know that the defendant was present at that hearing and was put on notice by the court that you were requesting to add that additional and that you would amend your complaint. You need to, well, I guess there's a issue here with the no contact order, so you can't probably mail a complaint to her. Okay, this is what I'll do, because I recognize this is an issue where there's a no contact order and an unrelated matter between the parties. I'll have my staff mail a copy of this notice in motion to the defendant to put them on notice that you've amended your complaint. Okay, sir?
Yes, Your Honor. Thank you.
Thank you. You're all set. And I think you already have a jury trial or a bench trial date.
Yes, I do. It's on the 6th.
Okay, we'll see you then.
Thank you very much, Your Honor.
You're welcome. Okay, Mr. Brunette, were you and Ms. Page able to work out a resolution on this?
Yes, we were, Your Honor. I don't know if you want to call the case again, we can kind of briefly lay it out for you real quick.
We're back on the record in the matter of Lansing Automaker Federal Credit Union versus Odelia Page. You can place a new arrangement on the record.
Okay, thank you, Your Honor. We've actually reached a settlement, so to speak. Ms. Page has agreed to pay the amount in full of or a settled amount, if you will, of $2,000. She's prepared to send that out. She's planning on sending it out this week to us, and then if we receive that, we'll dismiss the case, or satisfaction of judgment, if you will. I I think like to request perhaps like an adjournment of the objection today, just to give her time to get that to us, and then if she doesn't, then maybe we can kind of reassess at the adjourned hearing date, if that's okay with the court.
That's wonderful. We'll set it out 2 weeks.
2 weeks.
April 11th at 2 p.m. Ms. Page, do you have any questions today?
I do not know, Your Honor.
Okay, very good. Any additional matters for the record, Mr. Brunette?
That is all, Your Honor. I appreciate it.
Thank you. I appreciate you both for working that out, and you're all set for today. Okay, Ms. Page?
Thank you.
Thank you.
You're welcome. Okay, Catherine Boland is present, and I do see the attorney for credit of court. I'm gonna put you in a private meeting room so that you can either come to a resolution or you can complete a joint pretrial statement, okay?
Okay.
I can't even hear it as you stop. Why won't it let me start video? There.
Okay, Ms. Oliver, were you able to get the matter resolved?
Yes, Your Honor.
Let's see, run the record. In the matter of Credit Corporation Solutions versus Catherine Boland, file number 22-02811. All right, counsel appearance for the record.
Thank you, Your Honor. Good afternoon, Lynn Olivier, appearing on behalf of plaintiff.
Okay, and then Ms. Boland, can you hear us?
Yes, it won't let me use the video. It says I can't start the video because the host has disabled it.
Yeah, I definitely haven't disabled any videos, but. let's
Here it
see.
goes. Now it's back. Yay.
Very good. Okay, the parties have met privately, and Ms. Oliver, how are you going to proceed on this?
The parties agree to the entry of a consent judgment for plaintiff and against defendant for the full amount as paid for in plaintiff's complaint, that being damages of $1,713.30, costs of $82.99, statutory attorney fee of $75, for a total judgment amount of $1,871.29. The parties also agree that the defendant shall pay the judgment in installments of $25 each month, starting April 3rd, 2023, until the judgment is paid in full, and that the plaintiff shall not issue a periodic garnishment as long as payment is made.
Boland, that's a complete and accurate understanding of your agreement?
Yes, Your Honor.
Okay. And is anybody making any promises to you or threats to get you to enter a consent today, to a consent judgment?
No, Your Honor.
Okay. And did you, are you gonna get an agreement to her to review and sign this, Oliver, or did you just want her permission to have you sign the consent judgment on her behalf?
We can ask if she wants to give her permission.
Yes, ma'am. That's fine. Yes, Your Honor.
Okay, very, very good. Okay, and then Ms. Oliver, you can send us a copy of that judgment. You can actually email it to Judge Simmons Courtroom at lansingmi.gov.
Can you repeat that?
Yes, Judge Simmons Courtroom at lansingmi.gov.
Thank you. Okay, I will sign both our names to it and email it to you.
Very good. Any questions at this time, Ms. Boland?
No, Your Honor.
Okay, any additional matters for the record, counsel?
No, Your Honor.